Hello everybody, and thank you for joining us for this session of the Privacy Rules webinar series. My name is Alessandro Di Mattia, I'm member of the managing team of Privacy Rules, and I'm joined today by our colleagues from China and Russia that are Sophia Han from the Chinese law firm Zonglun and Stanislav Rumyantsev from the Russian law firm Gorodisky and Partners. I'm really glad to speak with them today because we are going to discuss two very interesting main topics that are the data localization requirements and the data flows between those two countries. In order to better address those topics, we are going to touch 6 different subjects that are divided with the 6 different slides that you can also find and download on our comments below. Those slides will be related to the legislation structure in the two countries, the applicable scope of the legislation in the two countries, and then the definition of personal data, so that we can then move on the real topic of the day, that are the data localization requirements and the cross-border data flows, in order to conclude then with the liability and the risk connected to those activities. There is lots to discuss today, so without further delay, I would like to leave it to our speakers, and I thank you all again for joining us.
Hello to everyone. The structure of legislation in Russia is pretty simple. We have only one federal law applicable to all kinds of data processing. You can find specific rules regarding employee data, financial matters, and some other specific cases in other pieces of legislation. But the federal law on personal data is the main document. This document provides for data subject rights, main obligations of companies and other entities processing data, main responsibilities, functions of the data protection officer, and other important issues.
Hello, everyone. It's been a great honor to be here to introduce to you about the Chinese legal framework regarding the data protection. Coming into effect on 1st June 2017, China has published the cybersecurity law, which established the legal foundation of the cybersecurity and data protection. And you may see that it's quite complex of the legal framework regarding the data protection and also the cybersecurity part in China. You may see it on the slides. We introduced to you about the legislation levels of all the laws and regulations and also the national standards regarding the data protection. Here we introduce to you and give a brief about the difference regarding the laws and rules and regulations here in China. And you may see that China has plenty and quite different levels of the authorities, which have different administration government power regarding different industries and different kind of operators and companies here in China. So you may see that the Chinese legislation structure is quite complex, and we have plenty of legal requirements and obligations for different kinds of companies here. This slide shows the Chinese legislation on cybersecurity and also the data protection under the CSL, which we mean the cybersecurity law here in China. You may know that data protection is only one key part of the cybersecurity law. And we also set up several new obligations for companies, which mainly include the following systems and schemes. The first part is called multi-level protection scheme for cybersecurity. I may say that it's quite different and special legal requirements under the Chinese legal framework, because as we know to nowadays that maybe it's the only country brings these special cybersecurity protection scheme here. And the second is a series of obligations of cybersecurity protection for network operators. the definition of network operators is unique and special under the Chinese legal framework, and I may brief to you on next slides. And the third part is the identification of the critical information infrastructure. You may know that Chinese government bring these specific legal definition of the cyber information infrastructure. We call it as CII, and the operators of these CII shall comply with the special and specific legal requirements under the law. And the fourth part is about the personal information and user information protection scheme. Here in China, we don't use the definition called personal data. We use the saying of personal information. And you may see that the definition of Chinese legal law and the Russian law is shares a lot of similarity, but also shares several differences between the two definitions of the two countries. And the next part is the data localization requirements of the cross-border data transfer. And we also have some special requirements regarding the network products and services. And we share the catalog scheme for some key and critical network equipment and specific network products here in China. So you may see that from this legal framework here in China, you may have the whole picture of the cybersecurity law here in China, which stipulates that not only about personal data is regulated here in China, we also have other kinds of data is highly regulated here in China. And besides that, we also have a series of obligations of cybersecurity and data protection here in China. So you may see that it's quite a complex legal framework here in China regarding the data protection and also the cybersecurity law here.
Thank you very much, Sophia and Stanislav, for this brief introduction that was very dense and that gave immediately us the idea of the difficulties related to the use of data in different countries and the differences that there are between China and Russia. Now, I would like to start discussing about the applicable scope, this time starting from you, Sophia, of your regulation in China.
Yeah. So this slide may show the first big difference between the Russian law and Chinese law. You may see that as the applicable entities here in China, we have two scope of the legal entities. We call it, one is network operator, which means the network owner, the administrator, also the products or service provider. So here you may understand, generally speaking, all the entities, legal entities and companies here in China would be deemed as network operator. So all the network operators shall comply with the cybersecurity law, which regulated the series of the data protection and cybersecurity obligations, which I mentioned before. So the second scope of the legal entity and responsible entity here is called critical information infrastructure operators. That means, like I mentioned just before, the operator of the CII. So the CII refers to critical information infrastructure in important industries and also the sectors, such as the public communications, information services, energy, transport, finance, public services, and e-government. So you may see that the CII is categories by the different industries. And the how to define and determine which kind of infrastructures will considered as the CII it's determined by the risk and result oriented. So you may see that under the definition of the CII, which stipulated clearly by the law, is that severely threaten the national security, national economy, and people's livelihood and public interests. So that's the definition about the CII. So you may know that not all the infrastructures which operated or hosted by the companies here in China will be deemed as CII. Only the critical one, only the important and have the fully and severely threaten to the public interest or national security and national economy. Here as that. So that's the brief of the CII here in China.
Thank you, Sophia. And Stanislav, what about Russia and the applicable scope there?
The Russian personal data law applies to data operators. There are no GDPR-style terms like controller and processor here in Russia. We have our own term data operator. The operator is an entity, governmental body, or even a natural person who anyhow deals with the personal data. The data operator must determine the purposes of processing and the means of processing. The data operator can also process personal data by itself or himself or herself, if we are speaking about a natural person. The data operator may also instruct some other party to process the data. I mean, to involve a processor. So if your company falls under this definition that you may see on the screen, then Russian law should apply to you.
Thank you very much, Stanislav, and that's really interesting. And we can now continuing with you with the next slide that is related to the definition of personal data. That is a really interesting topic. I think it's really important to stress the fact, as you mentioned, that those regulations are really different to GDPR, and that's something we always try to stress, the fact that it's not just about GDPR, but there are many other regulations that we need to respect, in particular when you work internationally. So thank you, Stanislav, for underlining this point, and please let us know more about the definition of personal data in Russia.
The definition of the term personal data looks like the definition under the GDPR. It's really very similar. Personal data means any information relating to a directly or indirectly identified or identifiable natural person. And this person is called data subject. The only important difference is that we do not mention online identifiers in the Russian definition. However, according to the recent case law, online identifiers may be also considered as personal data. So Russian law uses one-size-fits-all approach. The legal term personal data and the definition is established for the whole legislation. We apply it all the time in all situations. And to my understanding, this is a very important difference from the Chinese legislation. I hope Sophia can explain how it goes there.
Okay, thank you. And as you mentioned that the personal information under the Chinese legal framework share a lot of similarities with the GDPR and also with you in Russian. But we also have some quite differences between the two countries. The personal information here in China refers to various information which is recorded in electronic or any other forms, and used alone or in combination with other information to identify a natural person. That's the definition under the cybersecurity law, which is the most basic data protection law here in China. And we also have a specific definition which is stipulated in the national standards. You may know that national standards here in China is not the mandatory law here. It's only provided to the companies or governments as the good practice in the industries. But here in China, the personal information security specification, this specific national standards plays a key role here, not only about the data processing activities in the around the companies, but also play a key role here in China in the authorities and the government activities. So you may see that the key issues here in China regarding the definition of the personal information, or we may say that the personal data here, the two key issues is identifiable, and also the used alone or in combination with other informations. So that's the two key issues under the definition of the personal information here in China.
And I think, yes, now Stanislav can move on with your definition of sensitive data that is always related to personal data, of course.
The Russian personal data law provides for a comprehensive list of data categories that may be considered as sensitive data. The list includes convictions, statement of health, political views, ethnical origin, and some other data categories. According to the Russian legislation, in most cases, it will be necessary to obtain a written permission from the data subject to process these data categories. There are also some other restrictions and even prohibitions to process these data categories in certain situations.
So regarding the personal sensitive information here, you may see that it's also the risk and result oriented. The definition of personal sensitive information refers to the personal information that may cause harm to personal or property security, or is very likely to result in damage to an individual's personal reputations or physical or mental health. That means we share some similarities with GDPR or the Russian law here regarding the sensitive data, but we also share a lot of difference. And you may see that on the slides, we listed the examples of the personal sensitive information here in China. You may see that on the slides, we set out several examples about the personally sensitive information here in China. And you may see that the bank accounts, the cars numbers, the property informations, which regarding to the credit and financial info of personal subjects should be deemed as personal sensitive information. And we also share some similarity definitions and categories of these sensitive data. And you may see that the personal information of children which under the age of 14 here in China would be deemed as the sensitive data as well. So in China, we put the children's online privacy into the scope of personal sensitive information. And once the data is deemed as sensitive data, the compliance requirements and obligations would be severe and highly regulated than the general personal information. So under the legal framework here in China, the operators or the data controllers shall obtain the consent of these data subjects and also notice the rules of the data processing activities here in China. Then I will brief to you the special definition of important data here in China. As I know that in Russian you don't have this similarity of the definition of important data, but in China, the important data refers to the kind of data which directly affect the national security, the economic security, and social stability, or the public health and security, which means that the definition of the important data or the key issues to determine whether the data will fall into the scope of the important data is based on the results and legal risks here in China. And you may see that the national security or public health, public interest is the first result oriented here in China. So we set out several critical industries here in the slides, and you may see that the categories may involve important data here in China. So as I mentioned, that would give you the whole picture about the important data here in China. And the important data and personal information will be regulated links to the data localization requirements here in China. And I will give you a brief on this. Thank you.
Thank you, Sophia. It's really interesting to see that you have very specific peculiarities in China as the definition of important data that distinct your framework from other countries. And now we can move to our next relevant topic of today, that is data localization requirement. That is something that I would like to start discussing with Stanislav to have the Russian perspective now, and then move again to Sophia.
The Russian law, the localization requirement applies only to the personal data of Russian citizens. The localization requirement must be fulfilled by all data operators who collect personal data within Russia. It means both offline and online data collection. If you have a global website, but this website is intended specifically for Russian citizens, then you must comply with this requirement. For example, the localization requirement applies to cases when your website is translated into Russian and you accept payments in the Russian currency. The localization requirement applies if the website has a Russian domain name. Of course, the localization requirement applies to all cases when you collect some offline data, for example, for marketing and other business-related purposes. I can explain you how it works on the shim. Now I can explain you how the localization requirement works. Let's imagine that we have a data subject on the left part of the screen. This is the citizen of Russia, and we have some company registered in China, and this company would like to do business through a Russian office. This company would like to receive some personal data from the Russian citizen. What does it mean in practice? If the Russian office is in charge of processing and collecting personal data, first of all, the Russian office should establish a local database. This can be any organized array of data, beginning from an Excel file and up to a third-party data center located somewhere in Russia. The server can be located within the Russian office or outside, that doesn't matter. But the thing is that the local database must be somewhere within the territory of the Russian Federation. As soon as this local database is established, the Russian office must notify the Data Protection Authority of Russia about the address of this local database. And then personal data of Russian citizens can be collected, and upon collection, this data must immediately go to the local database. After that, it will be possible to take a copy of this database and send it to the main hosting or main processing facilities, even if they are located outside of Russia. And then the head office can receive this information and process it outside Russia, on the condition that the local database will be still in Russia. You should not delete the local database unless you complete the processing of Russian personal data. Of course, there are some rules for the cross-border data flows, and we will speak about them on the next slide. But now let's see what's the difference with the Chinese legislation.
Thank you. And here in China, we also have the data localization requirements, maybe quite different from the Russian law. The cybersecurity law has stipulates that the CIIO shall store within the territory of China about the personal information and also the important data, which collected and generated during its operation within the territory of China. So you may understand that the two steps of data here in China shall follow the data localization requirement. One is the personal information, and the other one is important data. So to figure out which kind of data should comply with the law, and first step you may review is to identify the data type. And the second manner is to see that whether this kind of data is collected or generated here in China. So that's the key issues or the definitions to determine whether these data should be localized here in China. We only regulate the data collected and generated here in China. So as for the companies or legal entities or the data controllers here in China, you may understand that there are two manners to collect or process the personal information here in China. One is directly collected from the data subjects, and the other one is the indirectly manner, which means one legal entity collected or received these data from another legal entity here in China. So that's the two manners here for an entity to collect the personal data here in China. So you may see that the scope of the data localization requirements under the cybersecurity law is only refers to the CIIO. That means the operator of the CII. But the Chinese government and authorities has published a series of draft measures for the security assessment of the personal information and the important data, which you may see that the personal information and important data by all the network operators shall follow the security assessment rules here in China. That means the scope of the responsible entities has been broadly and expanded from the CIIO to all the network operators, which means Well, you may consider that all the legal entities and all the companies here in China shall follow the rules. So the principle here is to localize and store these personal information and important data here in China. But due to the specific business operation needs, the entities or companies could cross-border transfer these personal data and important data. But as the principle here, these companies shall apply to the security assessment regarding these data to continue the data transfer processing activities. So we may see that in next slides. So as I mentioned before, not only about the personal information and the important data are highly regulated here in China. We also have some special business data here in China shall follow the specific localization requirements. So we set out several usual kind of these special business data here to give you a brief and clearly information about these regulated kinds of data, which you may see that credit data, the financial information regarding the personal subjects, and also the map data, as I mentioned, for example, the GPS data, and also the health information and the insurance data regarding the personal information, and also regarding the whole public interest and the whole publics here in China. So this kind of data shall comply with the special requirements, which regulated and officially published by each authorities in different industries here in China. So you may see that it's quite complexity here regarding the data protection legal framework here in China.
Okay, so thank you, Sophia, again, and Stanislav, and now we can move to the next topic that is related to the cross-border data flows, that is probably the prosecution of what we have just discussed. We know that in both your country you have to localize data coming from the people of each of them, and that's really interesting. So we can now move on and see how you can have a flow of those data, and I would like to start again with Stanislav and then move to Sophia.
According to Russian law, cross-border transfers of personal data are permitted. However, there are two groups of countries. The first group is the countries ensuring an adequate level of data protection. The data can be freely transferred to such countries, to the territories of such countries, without any specific formalities. The second group is the countries that do not ensure an adequate level of data protection. Unfortunately, China belongs to the second group, and it means that we should comply with a number of formalities to send personal data to China. Let's go to the next slide. On this slide, you may see some derogations applicable to the countries not ensuring an adequate level of data protection. First of all, it is possible to send personal data to such countries if you have a written permission of the data subject. It is possible to get one, for example, if you deal with your employees in Russia. But in case of e-commerce, it may be really challenging to receive the written permission in line with all applicable formalities. That is why a very common derogation is the performance of a contract concluded with a data subject. If you have this contract and if it is really necessary to send the data, to fulfill your obligations under this contract, then there is no need to obtain a permission. Russian law does not provide for any standard contractual clauses or similar safeguards. Consequently, you should rely only on these derogations.
So let me introduce the security assessment scheme regarding the cross-border data transaction here in China. So you may see that in China, these two kinds of data, personal information and also the important data, shall fall into the scope and apply to the cross-border cybersecurity assessments before the cross-border transmission activities. And these kind of measures are only draft versions. For now, they are not officially published yet, but it is assumed to be published next year. So as for the foreign companies or national companies here in China, shall pay important intentions to these cross-border data transfer measures. And you may see that regarding the personal information, before the cross-border transfer, the operators, all you may understand as the data controllers, have to obtain these consents of the data subjects. It's the first step. And then you shall apply to the local cyberspace administrations for the security assessment activities. So that requires the companies to apply for and file with the local administrations with the kind of data, the scope of these data, or the volume of these data, such as this. And regarding the important data, which before the cross-border transfer activities, the operators and the legal entities shall report to the departments for approval. That means only filing is not enough for these important data cross-border transfer activities. The companies shall obtain the approval from the governments before the cross-border transfer of these important data. And this slide shows the security assessment procedure regarding the data, the personal information. And you may see that the draft measures has stipulated several application materials regarding the application and filing work from the data controllers to the local governments. And you may also see that the focus of assessments refers to several key issues here. The first one is, does the transfer comply with the relevant state laws, regulations, and policies? That you may see that obtain these consents from the personal subjects would be the principle here. And the second key issues is, can the contract terms fully protect the rights of the personal information subjects concerned? This means to protect the personal data subjects here in China. The data receiver outside of China should also comply these regulations and fully protect these rights regarding the personal data subjects. And the next key issues is that, can the contract be effectively carried out? And fourth one is whether the network operators or receiver has a history of infringing on the rights of personal information subjects or had a major cybersecurity incidents in the past. That's the key issues to check out whether the receiver outside of China has the same protection abilities as the operators here in China. And the next one is whether the network operator obtains the personal information at issue in a legal and legitimate manner. And that means that the collection and processing of the data should clearly comply with the laws and regulated. And then you may have the legal base to cross-border transfer it to the outsiders. And you may see that the security assessment is to be complete within 14 working days. And as for the complicated cases, the timeline may be extended. Well, the whole picture here regarding the cross-border data transfer of the assessment procedure is only in the draft measures, which is not officially published yet. So once these measures will come into effect in the next year, the structure here maybe varies and has some changes.
Okay, thank you very much, Stanislav and Sophia, for this very interesting overview on the regulation in your respective country. And now that we have an idea on what we are talking about, I think we can move to the last topic of the day, that is the one related to liability. And I think it's one of the most interesting ones for our listeners, because everyone is always frightened about the risks related to the use of data, and we want to give them an idea on which are the risks when you don't comply with the Russian and the Chinese regulation. So we have now an overview from Russia, and then we will move again to the one of China.
Russian law provides for several types of liability. In most cases, personal data breaches may lead to administrative fines. The fines can be imposed on the companies and their managers. In most cases, chief executive officers and the data protection officers. The maximum amount of fine was established on 2nd December 2019. Last week, Russia established new fines for breaching the personal data localization requirement. For the first-time breach, the maximum fine is around 85,000 euros. And for the repeated breach, the amount of fine can be more than 250,000 euros. So it's really important. Sophia?
Yeah, so let me introduce the liabilities here in China. So regarding the personal data protection scheme, most case is referring to the administrative publishments. But you may see that here in the slides, not only the penalties here in China as the administrative manners. We also have the warning and detention, and also the ease of the business operations or revoke of the business license. So that may severely impact the business operations here in China if the companies illegally collect or process these personal information here in China, or illegally cross-border data transfer to the outside of China. So another key differences here, maybe from China to the most foreign companies, is that under the Chinese legal framework, we also have the criminal liabilities regarding the illegal processing of personal data. So as we all know that under the GDPR or under the Russian law here, we have different situations regarding the liabilities. But in China, the criminal liabilities is the severe one, and the infringement of the citizens' personal information cases is highly increased these years. So you may see that on the slides. There are, generally speaking, there are three kinds of illegally processing activities which may fall into the scope of the criminal liabilities here in China. The first one is illegally obtain and sell or provide more than 50 pieces of the personal information regarding the communication, the credit information, or property information. So you may see that the amounts of these data is quite low. So the possible to deemed as a criminal liabilities, I mean the opportunities is quite higher than maybe any other illegal processing activities in other countries. And the second one is illegally obtain and sell and provide more than 500 pieces of accommodation information, communication records, health and physiological information, transaction information, and other personal information that may affect personal and property safety. And the third one is illegally acquire, sell, or provide more than 5,000 pieces of personal information other than personal information provided above. So you may see that these three general kind of illegal processing activity is also legal risk and result oriented. Because here in China, the legislative activities is mainly determined and highly regulated based on the results. So once the illegal obtain or processing activities is highly or severe impact the personal data subjects, their rights or their security and their health security, and then it may trigger the criminal liabilities here in China. So I think that's that may be the big differences from the Russian legal framework.
Sophia, Stanislav, thank you very much for your really interesting and deep explanations. I really also want to thank our listeners of today, and I invite them to contact you for any issue related to the use of data, but not only, since we know that your firms have a great expertise also on other matters. So I invite them to look for your firms at zonglun.com and at gorodisky.com. And I would also like to invite them to download the slides that they can find on the comments below, because there they can find many other information on the experience of those two great experts that we had with us today. So in conclusion, I would like to thank you all, and I hope to see you very, very soon again. Bye.